appearance, beginning with plaintiff's counsel.
Your Honor, Aaron Finter on behalf of Plaintiff Castle Rock Homes, LLC, and we also have third-party defendants RLI, Rodney Fetters, and Beth Fetters.
Good morning, Your Honor. Mark Hansen for Barbara Perry and Derek Hayes.
All right. Well, good morning and welcome to everyone. I set this in response to the Court of Appeals mandate affirming the order denying the motion to compel arbitration. And I also have pending and have reviewed all of the briefing on the motion for leave to file the First Amendment complaint, as well as the motion to refile a narrowed version of defendant's motion for summary judgment on the remaining claims. So I wanted to start by giving you my preliminary thoughts, and then I'd like to hear both sides out on the issues that are implicated by the remand and the pending two motions. So my principal concern is that this case has been pending for quite a long time, and I don't see how I could grant leave to amend without also allowing the parties to reopen discovery, and not in a small way. Reopening discovery, I think the motion for Rule 16D implies that even though a third-party complaint is not proposed in the amendment, that the plaintiff would be looking to bring in third-party subcontractors, that they are then going to be entitled to discovery. So my concern is that while on the one hand, I am looking at the standard under Owens and the requirement that liberal leave to amend be granted, on the other hand, I am looking at the prejudice that the significant delay in seeking leave to amend would cause, and certainly having to reopen discovery would be would have a prejudicial impact on the defendants in this case. So for Mr. Finter, I'd like you to address, number one, if I don't allow a reopening of discovery, which I haven't thus far, would you still seek to amend your complaint, and how then would you prove your proposed contract claim and damages? And then also I'd like you to address that there was sort of the brief mention in the Rule 16 motion that you have an intent to seek leave to file a third-party complaint, and why it's not, if that's what you intend to do, already set forth in your proposed amendment and motion to amend. For Mr. Hansen, I think the thing I always struggle with is wanting cases to be decided on their merits and not defaulted on a technicality. So I would like for you to really articulate prejudice that would be suffered if I grant leave to amend. And relatedly, on your motion for leave to refile the motion for summary judgment, do you acknowledge that it's primarily based on Castle Rock's failure to disclose expert evidence, which is what they are requesting they be permitted to do by reopening discovery? So I wanted to give you those thoughts before we get started. That way I can hear you both out on those issues. And I'll start with you, Mr. Finter.
Yeah, thank you, Your Honor. I mean, the case does have sort of a long, tortured history, which is not uncommon for construction defect cases. I just wrapped up another defect case that was filed in 2021. I've got another one in front of Judge Blaney right now that was filed in 2022. So it's certainly not uncommon for these types of cases to go on longer than normal. As far as the timing of this case, I think it is relevant that there was a approximately 6-month time period early on where the parties were working on an extended mediation and appraisal process and effectively agreed to stay the case during that time period while they tried to resolve the case. We weren't successful, unfortunately, but I think that factors in to like the court's question of kind of why are things happening now? Well, there was approximately a 6-month period where the parties voluntarily were staying the case. And then, as the court's well aware, we sought to arbitrate the breach of contract claim. The court denied that. We appealed it. The case has stayed on appeal, and it wasn't until June where the Court of Appeals issued its mandate, and within days of that, we requested this scheduling conference and leave to amend our complaint. So certainly
Right,
it's
but
my
part of the problem is that the stay didn't, the appeal, the stay, even the motion to compel arbitration, which is part of why a waiver was found, didn't happen until most of these deadlines passed. In particular, the expert deadlines, where you were supposed to disclose the identities of your experts, I think by March, and then reports were due in May. And the appeal and stay all happened after that.
Yeah, the problem is we were concerned at that point that if we then did proceed with the case, then that was just really killing any ability we had to then arbitrate the breach of contract claim as we wanted to. And so we're kind of in a catch-22 position where if we are in fact litigating those claims, then it's going to be problematic to our position that we haven't waived our right to arbitrate at that point. So that was kind of the reason for that. What discovery has even taken place in this case to date? I think that's relevant, Your Honor, which is almost nothing. There's only been one limited scope deposition and a few written discovery requests. That's the sum total of all discovery that's taken place in this case to date. So our position is reopening discovery for a brief period of time with a schedule that gets us wrapped up on discovery potentially by the end of the year is not going to result in some prejudice to the other side, because it's unlikely that we're going to have some trial in January. I don't know what the court schedule is currently, but most of the trials that I have right now that are being set for mid-2027. And I don't think that reopening discovery at this point for a limited period of time so that there is in fact a decision on this case on the merits is somehow going to prejudice the defendants in this case.
Well, but reopening discovery as you're proposing it isn't just allowing a couple of fact depositions to occur or allowing already disclosed experts to occur. What you're asking me to do is completely reopen discovery so that you can issue brand new expert reports, which Mr. Hansen and his clients would then have to retain experts to rebut. You would then have to do more expert discovery. And then you're also talking about bringing in additional parties, are you not?
Potentially, yes. Whose scope of work is implicated in the defect claims.
Well, even setting aside your proposed amendment, that certainly is something that is implicated by the counterclaims that were filed a long time ago. Why, and well before anything happened with the motion to compel arbitration, what is the explanation for why third-party subcontractors on the defect counterclaim were not, why there's been no effort to bring them in sooner?
Honestly, Your Honor, I haven't been involved in this case from early on. I wish they would have been added sooner. And so I don't know that I have a great answer for the court, and I don't want to make one up, obviously. I would have liked them to have been added earlier on, absolutely, to get this case moving forward, but that did not take place.
All right. Thank you, Mr. Finner, and I apologize. I tried to give you my speech at the beginning so I wouldn't interrupt too much, and I still kind of did. So thank you for indulging that. Is there anything else you wanted to add?
Not at this time, Your Honor.
All right, Mr. Hansen?
Thank you, Your Honor. I'll address counsel's arguments really briefly and then turn immediately afterwards to answering the court's questions for me, if that's all right. Your Honor, this case, as the court knows, has been pending for more than 2 years. With respect to Castle Rock's request, Castle Rock is coming seeking a new Rule 16 scheduling order more than 2 years into the case, a year after the expiration of the actual scheduling order, and more than 5 months after the court already entered summary judgment against Castle Rock on its claims. That's where we're at. With respect to counsel's argument on the months that the parties spent attempting to mediate, the court already accounted for that time in its amended scheduling order by building each one, that delay, back into each one of the discovery deadlines. So that period has already passed. The court has already taken account into that in its amended scheduling order. This case, Your Honor, has already gotten more than 240 days for discovery as mandated by Tier 3 and Rule 26.2. It would prejudice Barbara and Derek to reopen discovery. I'll touch on that briefly later. With respect to the Court of Appeals and why Castle Rock didn't include its breach of contract and other claims already, the Court of Appeals, just like this court, found that Castle Rock had waived arbitration. What's waiver? Waiver is an intentional relinquishment of a known right or conduct showing that intent. In either case, Castle Rock intentionally made a decision. And it made its decision, it made a tactical choice here. And it needs to be held to that choice because that choice was intentional. With respect to why the third-party subcontractors weren't added before, counsel has said he doesn't have a good answer, and that's because there is no good answer. If you take a look at our filings, Your Honor, you'll notice that there is a June 2024 email from Rod Fetters of Castle Rock Homes, basically saying, hey, our HVAC subcontractor screwed up. What do we need to do to bring him in? And by the way, he's left us hanging on other projects too. That was in June of 2024. That was more than 2 years ago. Turning to the court's questions for me. We acknowledge that cases should be decided on their merits. Cases should be decided in accordance with the rules of civil procedure. This would reflect a decision on the merits because Castle Rock has chosen and made a tactical decision not to bring its breach of contract claim with its underlying complaint, even though the complaint mentions the contracts. Castle Rock made that decision. For the court to say, oh, a plaintiff can withhold, can bring part of its claims, but split them so that its original claims all get litigated over the course here of almost 2 years before the court entered summary judgment against Castle Rock. And then 5 months after that summary judgment is entered, to have the plaintiff come back and say, oh, we have this additional claim here that we would like to bring. Your Honor, that's claim splitting, pure and simple. And Arizona courts do not allow it. It completely defeats the purpose of the rules of civil procedure, be it Rule 1, be it Rule 26 and Rule 26.2, and the purpose of the commercial court, which is to foster the efficient resolution of commercial disputes. Castle Rock made a decision here, Your Honor, and Castle Rock needs to be held to the consequences of that decision. With respect to the prejudice that Barbara and Derek would undergo, Barbara and Derek have already been through over 2 years of litigation on this, including 2 trips up to the Court of Appeals on Castle Rock's interlocutory appeals that have both been denied. And they are left living in a house that the uncontroverted evidence shows is defective and unhealthy. And they've both given declarations as to what they have to go through, especially during the summer, which basically involves having to open up all of the doors and windows in the house to get actual fresh air in because the system constructed by Castle Rock does not allow for fresh air to enter the home. That means that they're exposed to the heat, to the dust, to everything that comes with it. This is not just plaintiffs who are going through a standard commercial dispute. This is plaintiffs, Barbara and Derek, excuse me, not plaintiffs, defendants and counterclaimants, but Barbara and Derek are living with this house and with this dispute every day. They're living with these defects every day. And to suggest that they need to basically continue to suffer for the next 6 months, a year, 18 months, as a discovery process restarts from scratch, including apparently the intent to bring in third parties that they've known, Castle Rock has known about since the very beginning. That's prejudice, Your Honor. Not just the cost and the expense of having to go through this, but having to live and to continue to live in these conditions and with this lawsuit every day. Your Honor has asked whether our motion for summary judgment is based solely on Castle Rock's failure to disclose controverting evidence. The answer to that is no. The summary judgment would have been filed in any case because it's appropriate. Barbara and Derek's summary judgment motion is supported by expert reports. It's supported by witness declarations. It's supported by additional records. This is not just about Castle Rock's failure to disclose. It is about the fact that Barbara and Derek have evidence showing that there is no material dispute of a genuine dispute of material fact, and they're entitled to judgment as a matter of law under Rule 56. The court has seen the full extent of Barbara and Derek's evidence in their original motion for summary judgment filing back from August 4th of 2025, a little more than a year ago. There are dozens of exhibits. This is not just about Castle Rock's failure to disclose. This is about the fact that Castle Rock's work was plainly defective. Barbara and Derek have been and continue to be damaged by those defects. And it is time to wrap this case up, Your Honor. It is more than 2 years after this case began. And we are simply asking for leave to refile the same motion, just a streamlined version, incorporating the court's most recent rulings, showing that Barbara and Derek are entitled to summary judgment. Does Your Honor have any claims for me or questions for me?
I don't. Thank you, Mr. Hanson. Mr. Finter, is there anything that you wanted to add in rebuttal?
Yeah, just briefly. I mean, the defendants agree that the case should be decided on the merits, but then also said that somehow if we were not able to bring a claim, it would be decided on the merits, which doesn't make any sense. If we're not even able to bring the claim, then there could never be a decision of that claim on the merits, which the defendants have agreed is appropriate. And I think it's unfair to say that this case has been litigated for 2 years. That is not accurate. There's only been, over the last 2 years, perhaps 6 months of active litigation in this case. I don't think that it's likely that this case is somehow wrapped up on summary judgment. There's fraud claims that are included in there, and there's been zero discovery on the fraud claims. And I guess I've never seen a case where a fraud claim was successful on summary judgment without discovery. So I guess we would again submit that a brief extension of the schedule is appropriate in this case, and it's not going to result in the actual prejudice to the defendants because it is not likely that there is going to be a conclusion of this case absent that before the end of the year anyway. That's all I have, Your Honor.
All right. Well, thank you both for your argument today. I'm going to go ahead and give you my ruling and explain to you why I'm doing what I'm doing. Obviously, Rule 15 provides as a baseline that leave to amend should be freely granted when justice requires. But Arizona cases provide that undue delay and related undue prejudice are reasons to deny leave to amend, in addition to futility. And relevant prejudice includes the additional inconvenience and delay caused when the proposed amendment would require reopening discovery for new factual development, expert disclosures, which in this case, in all construction defect cases, they really revolve around experts, and they are very expensive and time-consuming as a result. So in this case, it's been pending for more than 2 years. Castle Rock knew of its contract and payment issues from the outset. Those issues have also been part of the Perry and Hayes counterclaims since 2024, but there has never been any assertion by Castle Rock of an affirmative breach of contract claim during the period where disclosure and discovery were open. Those deadlines expired in the spring of 2025, and since that time, I have entered summary judgment on the 2 claims that were pled in the original complaint. I can't overlook the history of the arbitration issue because Castle Rock didn't seek to compel arbitration until after about a year after the counterclaims were filed, and also after the expert disclosure deadlines passed. at this point, the thing that concerns me more is the admission that the path forward, if I were to allow amendment, isn't we just need to take a couple of depositions. It is we need to completely restart the case essentially from the beginning, reopen expert discovery, bring in third-party subcontractors, and that would be prejudicial in the sense that it would significantly delay the case further. It would increase the party's expense substantially. And I don't find that the interests are served. Rule 15's purpose is served by allowing that to occur in this case, given its history. So I am going to deny Castle Rock's motion for leave to file First Amendment complaint. I also want to talk about the motion for leave to refile the motion for summary judgment. The original motion was timely filed under the original scheduling order. I declined to rule on the portion of it that related to Castle Rock's claims because of the pending appeal. So I am going to allow the defendants to refile their what otherwise was a timely filed motion on the remaining claims at issue. That doesn't mean I'm going to grant the motion, but I'm going to allow it to be refiled. For that reason, I'm not going to reset trial at this time, even though I'm not reopening disclosure and discovery deadlines, and I'm denying the leave to amend. But what I'd like to do is set a deadline for you, Mr. Hanson, to refile your motion, because I want to have a ruling on the summary judgment before we proceed to trial, because it has a significant impact on trial time if I grant it in whole or in part. So can you tell me, Mr. Hanson, when you can get your motion refiled on the remaining claims?
Certainly, Your Honor. I have a partner who's my other civil litigation partner who recently suffered a stroke. I've been covering her calendar as well. Could we get 2 weeks to refile that motion for summary judgment?
Yes, that's fine. So that would be August 21st, 2026?
That should work, Your Honor.
Okay. Any problem with that as a deadline for the filing of the motion, Mr. Finter?
Oh, absolutely not, Your Honor.
Okay. So it is ordered granting Castle Rock's motion, granting counter claimant's motion for leave to refile motion for summary judgment. The motion shall be refiled on or before August 21st, 2026. Obviously, the response deadlines and reply deadlines for briefing on that motion will proceed pursuant to Rule 56. So I believe that addresses everything that's at least outstanding as of right now. Is there anything else? One thing that I wanted to raise as an issue, I know that you spent a lot of time trying to resolve this case early on, and I don't ever like to force people into ADR or mediation if it's not going to be a good use of your resources. That said, litigation, especially this kind of litigation, is very expensive. And we have some very good civil judges. I'm thinking of Chris Corey in particular, who are very skilled at helping parties get over the hump and in resolving cases. Chris Whitten as well, and or anybody else you've used that you think might be good. So I probably have offered this before, but I just wanted to reiterate my offer, if I had, or to tell you if I haven't already before, that if the parties want to pause, have me reach out to one or more of our civil judges to see who's available to do a mediation for these parties. I would be more than happy to do that, because I think it might be, and again, I will defer to you on that to give you a chance to talk with your clients and with one another to see whether or not that's a good use of your time. So all I'll tell you is if that's something the parties are interested in participating in, and all you have to do is email my division jointly. Let me know that you are interested. If you have a particular judge, one or more judges that you'd like me to reach out to first, just try and get something set up, I will do that. I can't make promises about their availability, but I have not had trouble finding volunteers, and I do the same for my colleagues. So if that's something the parties are interested in, the only thing I ask is that everybody really come to the table in good faith, so that it's a good use of time, even if you don't settle it you've still got to be in the right mindset. But if everybody is on board, then I'm happy to make those arrangements for you all. If it's worthwhile, there are different inflection points in a case where it's sometimes a good idea to think back about whether this is a good time to talk settlement again. So just please know that I will make myself available to try and get something arranged for you if you both confer with your clients and each other and you decide that's something that you think might be helpful to you in getting it resolved. Okay?
Yes, Your Honor.
All right.
Thank you, Your Honor.
Thank you, everyone. Have a nice day. We're off the record.